The member for Heffron.
Madam Acting Speaker, I've taken the opportunity to read the contribution in the second reading speech of the member for Balmain, and I certainly appreciate the matters he has brought to the attention of the House, and I agree with much of his policy response, as do I agree with what the objects of his bill are, and that is to require the exercise of a function to be consistent with the objects of mitigating, adapting to climate change and for related purposes. The question is whether or not this bill is the appropriate response to adopt a policy. I'm in the position that I have always taken generally in respect of legislation is to ask whether or not legislation is an appropriate response to enact a particular policy provision. This Parliament has a history, particularly in recent, I was going to say years, decades, of overreacting in a policy response by the introduction of legislation. With the best will in the world and with detailed consultation, there are always unintended consequences, and usually there is always a response to address a media story without consultation where there are considerable unintended consequences. In fact, law reform in this state, unfortunately, is littered with legislative responses to media articles rather than consideration as to whether or not a legislative response is required or whether or not common law or the decisions of the courts are sufficient to be able to enable a policy response. If ever there is an example of a fine piece of legislation being destroyed by a legislative response, it has been the repeated amendments to the Environmental Planning and Assessment Act 1979, a groundbreaking piece of legislation that has been destroyed successively by successive governments since about 1990. Now, I'll come back to that. I just want to deal with the attempted policy response by the member for Balmain, and why I say that the bill in this form is not the appropriate policy response, and why I say this continues to repeat what I consider to be a parliamentary error in dealing with the Environmental Planning and Assessment Act. Now, firstly, when the New South Wales Land and Environment Court Chief Judge, Justice Preston, handed down its decision to refuse the Rocky Hill coal mine in the Gloucester Valley, that decision effectively had international ramifications, Madam Acting Speaker, because although the court held that the project should be refused due to its significant and unacceptable planning, visual and social impacts, it was actually Justice Preston's consideration of greenhouse gas emissions of the proposal and the impact of those emissions on the climate system, environment and the people that has changed the law in New South Wales. The Rocky Hill case and because the Land and Environment Court is a court of superior jurisdiction, and its decisions, if they be the court's ratio, are binding decisions as a matter of law. Now, the Rocky Hill case comes in the wake of an international agreement made in Paris in 2015, and that agreement provides, quote, to keep the increase in global average temperature to well below 2 degrees centigrade, above pre-industrial levels, and to limit the increase to 1.5 degrees centigrade, unquote. Now, evidence was placed before the court where expert evidence provided that a carbon budget, that is, the caps of the amount of global emission that can be released in order to maintain warming below a certain temperature, must be adhered to if the objective is to be reached. Now, whilst in arguing that refusing a single coal mine in the Gloucester Valley may not help in the long-term impact of climate change, and I imagine that that would be the argument made by those opposite if they have sought to do so repeatedly. Justice Preston summed it up when he said this, significantly, I quote, "The global problem of climate change needs to be addressed by multiple local actions to mitigate emissions," close quote. The main point of contention in the Rocky Hill case was whether the coal mine was able to proceed on its merits, looking at what's known as the carbon budget and the need to limit global warming to 1.5 degrees centigrade at post-industrial levels. The court found that the greenhouse gas emissions of the project and their likely contribution to adverse impacts on the climate system, environment and people were a reason for that refusal. Now, Madam Acting Speaker, in my view, the outcome should not be controversial because decision makers are tasked with assessing the impacts of development proposals on the natural environment and on communities who are already living with the impact of climate change. The science is clear that limiting the effects of climate change is necessary to achieve sustainable development and intergenerational equity, and is in the public interest, all of which are considerations under the Environmental Planning and Assessment Act. All are currently required to be taken into account when determining development applications. Now, prior to Justice Preston's decision, there were no specific climate change laws in New South Wales. There is as a result of the Rocky Hill case and the decision of Justice Preston. Now, whilst the member for Balmain and the Greens, as well as the Environmental Defenders Office, argue that planning law lacks the specificity needed to ensure that we are reducing greenhouse gas emissions in order to limit warming to 1.5 degrees centigrade and effectively protect the environment and communities already at risk from climate change, the fact of the matter is that is inconsistent with the decision in the Rocky Hill case. Unless they want to argue, of course, that it's not the ratio decidendi of the case and it's simply obiter dicta. I don't agree with that assertion because I think Justice Preston went out of his way to specify the principle that needed to be applied. Now, so even if I'm wrong and the member for Balmain and the EDO are right, then Labor in itself has also been working on a bill to try and address those shortcomings. But as Labor works down that path, it needs to consider the very principles that I'm bringing before the House, and that is whether or not legislation is needed as an appropriate response. Now, I just want to remind the House why I say what I have said, and that is I just want to invite the House's attention to what used to be Section 5 of the Act, and now they've renumbered it, which is confusing to someone that's part of the old guard like me. It's now Section 1.3, which contains the objects of the Act. And they're set out from A to J. But the first is to promote the social and economic welfare of the community and a better environment by the proper management, development and conservation of the state's natural and other resources. To facilitate ecologically sustainable development by integrating relevant economic, environmental and social considerations in the decision-making about Environmental Planning and Assessment Act. Clause E of Section 1.3. Madam Acting Speaker, might have an extension of time.
Member requests an extension of time. All of those in favour, please say aye. Aye. Against? Carried.
So, Clause E of 1.3 says to protect the environment, including conservation of threatened and other species of native plants, native animals and plants, ecological communities and their habitat. G, to promote good design, amenity of the built environment. And I won't read the others because time doesn't permit. But as you can see, the objects of the Act are pretty well all inclusive. Now there are two issues contained within this bill that concern me, and that relates to two of the clauses. One in clause 7 of Schedule 1, which is the ability of changing consent, and the other is clause 10 to 13 that relate to third-party appeals. And I say this highlights the problem, again, with a bill with fine objects, but again become a tinkering with the Environmental Planning and Assessment Act, and it contains the same ills as the pro-development lobby when they've changed the Environmental Planning and Assessment Act itself. And that is, there are always unintended consequences. Now, changing of a consent. Now, development consent attaches to the land and is based upon the material that has been provided to a consent authority or somebody that grants development consent. That consent that attaches to the land needs to be, in my view, final, absent fraud. To be able to have a consent effectively varied by adding a subsequent condition that in effect could make an approval, a development consent unsustainable, is not a way that would permit the encouragement of economic investment in this state. Now, I accept that there are major failings in the Environmental Planning and Assessment Act. I accept that consent authorities, and I know the member for Balmain's been part of a consent authority in his early life as I have been misled and have thought that conditions of consent would control a particular application. And ultimately, you would have loved to be in a position to have revoked that consent or added conditions to it, but the law doesn't enable it, and it is because the consent attaches to the land, there has to be some consistency. So I would much prefer, for example, there to be licensing for environmental impact statements so that these dodgy environmental impact statements are brought to a stop in this state, so the consent authorities have confidence. I would much rather criminalise material that causes a consent authority to be misled as an act of deterring accurate information before the consent authority, rather than coming along later, absent fraud, and being able to change a consent. So if you can do it for climate change, why can't you do it for something else? So, so that in itself becomes a tinkering with an act that has unintended consequences and cuts across the very fabric of the Act and how development consents should work. The other is third-party appeals. As a matter of policy and philosophy, I would support that. I would support third-party appeal, except how do you do it? You can only do it in the concept of looking at the Act as a whole, or maybe repealing everything from 1990, because what you would find if you allow third-party appeals is you would allow competitors to be able to utilise a third-party appeal process to delay the implementation of a consent. And that is not unheard of. I mean, I have seen it over the years for major developments. I saw it with the approval of Westfield's East Gardens when the then owners of Bondi Junction, which weren't Westfield's at the time, litigated in respect of approvals of that shopping centre simply because they didn't want the potential consumers or customers from their shopping centre to be going to Pagewood. They wanted to retain them in Bondi Junction, which is a prime example of what happens if you do not if you do not look at third-party appeals process as a whole and incorporate it into an act to give it some proper effect. So the theory is good, but implementing in this way is not successful. So I don't, as much as I value the member for Balmain's contribution, I'm not sure this bill is a way in which to achieve it.